Here's a situation that it seems not everybody could see coming, but they could certainly hear it afterwards. So welcome back, but if you're new to me and my channel, I'm a barrister who helps you understand law, and in this video talking about the master plan unveiled by National Grid to save people £10 per day on the trial days for using their washing machine at night. Amid the energy price crisis, National Grid came out with a plan to reward customers for using their energy at night. Indeed, many suppliers have a cheaper rate of electricity at night, but not everybody, it seems, expected this. Dear neighbours, 4 AM is not an acceptable time to use a washing machine. I've been woken up several times with your washing machine. Please stop. Refrain from using the washing machine before 7 AM. I've been woken up on too many occasions. This is very unfair when people are working. But whilst we're talking about energy, if you're trying to save energy and the costs of using your electricity, why not check out this meter that I've talked about in previous videos? I'll link the video in the description below, and I will link the meter in the description below. You simply plug it in and you plug a device in, and it tells you what power your devices use and how much it costs to run. Back to the video. Now, of course, this makes absolute sense because washing machines can make an awful lot of noise, particularly if you're in a terraced or a semi-detached house and you're sharing neighbouring walls. With the washing machine picking up speed, particularly on rinse cycles, it's obviously going to make a lot of noise, and it's undoubtedly going to wake some people up. So what can we do about this? Well, aside from the incentive scheme, you might actually be looking at some kind of common law nuisance, which might amount to a statutory nuisance. So allow me to explain. Anything that amounts to a private nuisance is actionable as a tort, as a civil wrong, and a would-be claimant can take civil proceedings against a would-be defendant either for damages to compensate them for the loss or injunctive relief to require the defendant to stop what it is they're doing that is causing this nuisance. Now, a nuisance, particularly a private nuisance, is usually something that is ongoing and having an effect on someone around you. Nuisance typically comes in 3 different forms. One might be encroachment over someone else's land, which is not the case here. Secondly, might be damage to someone else's land or something that is physically affecting someone else's land, which obviously isn't the case here. But the third, which might be useful in terms of noise, might be an interference with the quiet enjoyment of a claimant's property. Giving a broad example, if somebody had dog kennels next door to you, then you might have a loss of enjoyment of your property because of the amount of noise that the dogs within the kennels are making. All of this coming about, of course, because there is a very simple duty of care between neighbours. That is, the reasonableness between neighbours. The standard of which to be measured is that an occupier should be doing that which is reasonable to expect the occupier in those particular circumstances. That was decided in Goldman and Hargrave in 1967. Many of you might be familiar with the term statutory nuisance. This is where a piece of legislation sets out what might amount to a nuisance, but usually there will be a common law nuisance involved as well. That is because something that amounts to a statutory nuisance must usually also amount to a private nuisance or cause some other prejudice to health. Many of you might live next to tenants that have a landlord and ask the question whether it is the tenant or the landlord that is responsible for the nuisance. Well, in that case, it is the occupier who is responsible, so it will not be the landlord. It will be the tenant within that property that you'll be looking to if there is a nuisance going on next to you. But nonetheless, I can see various arguments to be raised here, because one of the things to be considered is whether or not the defendant was reasonable in the use of their land. Now, if there was an official trial going on for using washing machines at night, it might be argued that by using the washing machine at night, it was considered to be reasonable, or at the very least believed to be so, because the defendant was doing it as part of this trial. It's also important for how long and how often this is going on. For example, if washing machines were going on all night long, every single night of the week, that would almost certainly be unreasonable. If it was just once a week, perhaps for a couple of hours and not all night long, that might be considered to be reasonable, given that it might be part of this trial. All I can say in these situations as general guidance is that everybody should try to be reasonable and cooperative with each other. If you are using your washing machine at night, try to talk to your neighbours to do it at a certain time, so it's going to interfere with them as little as possible, because undoubtedly if they do sleep at night and your washing machine is on at night, I can see this as being a recipe for disaster. In the meantime, let me know in the comments box below, have you been using your washing machine or other machines at night? Have you benefited from this trial, and do you get cheaper electricity at night? Ours is currently the same, so we wouldn't bother using it at night, and we're not part of any trial. but I'm interested to read your views and comments. So if you found this video useful or entertaining, or any of my videos useful, please do hit that like button and subscribe. I will be holding some kind of celebration for 250,000 subscribers, which we will hit very, very shortly. So thank you all for watching, thank you for subscribing, and I'll see you next time.